My name is Edgaras Markevičius. I am a counsel here at law firm Sorainen. And today we're going to talk about life after submitting a bid in Lithuanian public procurement procedures. We have structured this presentation along the following questions. These are the most common, and they are relevant to newcomers to the market. We will try to answer them and give you a better idea of how the procedures really work in Lithuania and what can be expected after the submitting of the tender bid. For the clarity of this presentation, there are some abbreviations in the presentation, and CA means a contracting authority or a contracting entity, but you should understand it as your prospective client or the buyer. First, one of the most important things is the contracting authority's right or authority to ask questions. It often happens so that the tender bid submitted, it does need some clarifications or additional documents. The contracting authorities, they often find some things to be unclear. So therefore they are not only allowed to, but they are obliged to ask the tenderers questions about the content of their bid. There are a couple of limitations that are important to know. First of all, the contracting authorities, they are not allowed to ask for any new documents that were required to be submitted with the essential bid, and if the procurement conditions entail a ground that the tender bid will be dismissed if this document is missing. So essentially it is a formal application of the tender conditions, which will limit the right to submit additional documents. The second important aspect about the clarifications of tender bids concerns the essential modification of tender bids. They are not allowed by law, so if you find yourself in a situation where you would like to make changes that are essential to the bid you made, for instance, if you would like to change the product model or the manufacturer, or if you would like to change the date for the works that you suggested, these might not be possible because these can be considered as an essential modification of the tender bid. Next important aspect is the deadlines. They are not given in the law, and they are usually set individually by the contracting authorities when you receive a request to produce additional clarifications or give new documents. An extension is possible, and however you should clearly ask for it in writing and try to motivate your request for additional time. The contracting authorities, they are usually inclined to retain the tenderer in the procurement procedure because they want to conclude an effective and a competitive tendering procedure. Therefore, they usually are inclined to grant deadline extensions. How thoroughly should the answers be given? When preparing the answers to the contracting authorities' questions, you should not concentrate on the overall extent of them. However, you should concentrate on the clarity and content of your answers. The questions posed should be answered clearly and to the point, and because the offers of the tenderers, they are evaluated systematically, and the form is not given a priority. Another thing worth mentioning is a special case and special legal regulation regarding an abnormally low price review. If you encounter such a situation when a contracting authority requires you to clarify your tender price and to produce evidence that it is not abnormally low, you should bear in mind that the object of this process is to prove to the contracting authority that you will be actually able to perform the contract. You do not need to prove that you will suffer particular costs, that your costs will be lower than your tender price. Another question worth discussing is a special case regarding the abnormally low price review. Contracting authority has the right, and in some instances it is obliged, to ask for the tenderer to submit additional documents and clarifications to prove that the price they suggested is not abnormally low and is actually doable. you should always bear in mind that the object of this whole procedure is to simply prove that you understand the financial risks and you are ready to cover them and to fully execute the contract within the specifications you have given. Next slide concerns the contracting authority's right to request new documents in later stages of the procurements. It is worth to mention that the system is built in a way that the tenderer is not allowed to give documents on his own behalf. Rather, the contracting authority asks for any information that is missing or any unclear points that they identify. The contracting authority can only accept new documents, bearing in mind the limitations that we have previously discussed. Firstly, it is that if they do not concern an essential modification of the bid, and secondly, if the provision of these documents is not identified as a rejection ground for the proposal in the tender documents. An extremely important thing to know for a supplier coming from a foreign market and trying to enter the Lithuanian public procurement market is to understand the application of exclusion grounds. Exclusion grounds, they stem from the European Public Procurement Directive. For the most part, they are uniform throughout the European Union. However, the practices vary from country to country. In Lithuania, the suppliers are usually required to provide registry excerpts of that they do not meet the exclusion grounds. You should also know that the exclusion grounds, they are applicable not only towards the supplier as a legal entity. Some of the exclusion grounds, especially related to non-conviction regarding certain crimes, they are also applicable to the members of administrative and executive bodies of the supplier. In reality, this means that they are also applicable to the CEO, CFO, members of the board. You should also understand that other means to prove the absence of exclusion grounds, they are only allowed in exceptional circumstances when official documents are not available to be submitted to the contracting authority. There is a website and a tool called eCertis that allows for an EU-wide search of possible documents that prove exclusion grounds. Therefore, the contracting authority will have the means to check and to make sure if any particular documents proving the absence of exclusion grounds are available for you to submit. As the name suggests, this system only works towards the suppliers registered in the European Union. Therefore, representatives of and businesses from any third countries, information about them will not be available in this system. An important aspect for any successful business is a protection of business secrets. In Lithuanian public procurement, there is a general rule that the public procurement procedures, they are not confidential. As the name suggests, they should remain public. This is not applied in its absolute sense. The tenderers, they can request to apply protection of their data submitted to the contracting authority. Up until 2022, the national judicial practice was formed, and it allowed for the protection only of commercial secrets. Afterwards, also confidential information can also be protected during the public procurement procedures. If you believe that your bid that you are trying to produce may contain any confidential information, it should be marked as such in the tender bid that you are submitting. You should also be prepared to prove to the contracting authority that this information is indeed worth protecting and that it is confidential to you. Regarding the confidentiality, you should understand that in Lithuania, after winning the public procurement procedure and concluding a public procurement contract, the public procurement contract is made public in a national database, and it is available for everyone to see and download. And it also includes the tender offer bid of the supplier who won this contract. If you participate in a public procurement, however you fail to win it, your tender details will not be published and they will not be available to familiarize to your competitors who also participated in this public procurement procedure. Contracting authorities, they have a very wide authority in this regard. The national law, it does not stipulate any, and it does not set any time limit for a public procurement procedure. Public procurement procedures, they need to be conducted within the requirements of the law, and all of the tender bids, they need to be evaluated thoroughly. Therefore, it usually takes time. And the usual length of the whole public procurement procedure can be expected to be from 3 to 6 months if it does not include litigation. However, the law sets forth some deadlines that are very important to understand for you as a supplier. First of all, after the winner is announced, you are given by law the chance to familiarize yourself with the winning bid, and if you believe that it was selected unlawfully, you can produce a claim and try to abolish that decision. Depending on the type of the procurement procedure, the term for this is either 5 working days or 10 calendar days. After the winning bid is selected, and if no claims are received, the standstill period ends and the contracting authority is obliged to sign the contract. The law does not set any time limit for when the contract must be signed. However, the national court practice has formed decisions that says that public procurement procedures, they need to be effective and speedy. Therefore, usually contracting authorities do not hesitate and they promptly go to the last stage of signing the public procurement contract. If you have made a tender bid and you have, during the public procurement procedure, the market conditions have changed and you have identified a need to withdraw your bid, it should be noted that you can always do that. However, the consequences may be different depending on the conditions of the particular tender that you are participating in. Usually, the tender procedures, they require for the tenderer to submit a tender offer bond, which may be used in instances in cases like this, i.e. when a tenderer refuses to sign a contract. Additionally, the contracting authority in a separate legal process may require for you to compensate damages that the contracting authority has suffered when it was forced to select another bid that is more expensive than yours. None of this should be applicable if the time for the validity of your tender bid has transpired. Usually, the time for a tender bid validity is 3 months or 90 days. Contracting authorities, they take a variety of different decisions during the public procurement procedure. Usually, they require for the supplier to give any additional information or to answer any questions that they have identified. It is worth noting that all of the contracting authorities' decisions, they need to be motivated. This is an essential part for you to understand how to actually answer any question. And also, when facing a rejection of your tender offer, it is extremely important to understand the decisions on the motives behind that decision, on why your tender bid was rejected. The law does not state any time limits for any interim decisions that are being made during the public procurement procedure. However, the contracting authority is obliged to publish the results of any public procurement procedure within 3 days after making that decision. In reality, these decisions come pretty much a lot faster, and usually they are communicated to the suppliers on the same day that they are made. The contracting authority informs about their decisions via the national public procurement system. It is essentially the only way to communicate with the contracting authority, unless it is expressly stated so in the tender documents that you are participating. Instances like these can include any demonstrations, interviews, or submitting of examples of the object that is being offered. However, they need to be expressly detailed and given for in the tender documents. We come to the most important part of the public procurement, of the participating in Lithuanian public procurement procedures, which is disputing the contracting authority's decisions. The national law states that any decision of the contracting authority can be disputed if it undermines the rights or interests of a particular supplier. However, it can only be done so within the limits that are given also in the law on public procurement. The most important of them are the time limits. If a tenderer would like to produce a claim to change the conditions of a public procurement procedure, for instance, to change the term of the works or technical characteristics of the product purchased, such a claim needs to be submitted within 7 or 10 days after the public procurement is being published. If a supplier would like to dispute a decision made by a contracting authority during the evaluation of the bids, the supplier must also produce a claim within the same 7 or 10 day period after he is informed about the decision that he does not agree with. Regarding fees and procedural costs, producing claims to the contracting authorities, it does not include any fees or procedural costs. Suppliers are free to do that on their own accord, and no fees are applied. If a supplier disagrees with the answer of the contracting authority when his claim is denied, the only option left is to go to the courts. There are some court fees and procedural costs may arise. When applying to the court, the Civil Procedure Code of Lithuania states that the state duty fees must be paid depending on the nature and the value of the contract. It ranges from 300 to 15,000 euros. If a case is won, any additional these procedural costs and additional costs suffered for hiring lawyers, they may be recovered from the party who lost the dispute. On the contrary, if a case initiated by the tenderer is being lost, then he might need to cover the costs of legal defense to the contracting authority. And lastly, the contracting authority informs about the decisions being made via the same e-public procurement system that is used nationwide in Lithuania, and it is accessible online without limitations to national or foreign suppliers. Thank you very much for your attention. We have reviewed the most important things about participating in Lithuanian public procurement procedures, and should you have any questions, do not hesitate to contact us.